I am D.K. Williams. David Williams is, for those that know me, everybody can call me Dave, but I go by D.K. because there's another David Williams that sometimes people I don't want to be confused with. So it's been like that ever since I was in grade school. They put the homerooms, alphabetically. There's always been another David Williams. It's like John Smith. So throw in the middle initial, D.K. Williams. And I was at that very first LOTR at my brother's bar, right?
Yes.
That's where it was, right?
Early 2008.
Brad, were you at that? At that one?
I'm not that OG.
Okay, all right.
Oh,
But
Brad
good to
Jones.
see Brad in the house. Yeah, everybody needs to say hello to Brad Jones. Good to see you. But, all right, so I was there and you were there, the only two people in this room that were at the original one 10 years
Me?
ago. Yeah.
Was Susan on
No,
there?
Susan wasn't there.
Susan didn't. Yeah.
All right, so I've been here since the inception. Here to talk about the libertarian critique of the Supreme Court and some cases, Supreme Court cases. That sounds really, really boring, but it's not. Some of what I hope to talk about is really philosophical, as Justin was mentioning about philosophy. And I do think that politics are like the practical application of philosophy, or it can be. And you like that? All right. So, and one of the things that's happened recently is I'm a lawyer, and I still am representing a family in Greenwood Village. For those of you that this was in the news, and Rachel Maxson, my co-attorney, was here one time talking about it. Leo was here. I know Leo went to Westminster and talked about it. So I'm going to start off with this, because it does tie in with the Supreme Court, and it ties in with the Constitution. What happened to the Lex house was they had a house, they had a house in Greenwood Village, and a random bad guy who had tried to rob the Walmart down there where Hamden and Havana meet, tried to elude the police, ran across Interstate 225 and into a random house in Greenwood Village. Barricaded himself in there. The police knew where he was. Anyway, the police barricaded him in, brought in all their SWAT toys, right? The militarization of police, brought them all in. 17 hours later, they couldn't get the guy out, so they basically blew up the house. All right? They got him. So that's all they cared about. So Leo came to me, and I brought a lawsuit along with Rachel Maxson, who comes here a lot, basically saying that it doesn't matter if the police were reasonable, which is what they say they were, right? It doesn't matter if they're reasonable, because the Fifth Amendment to the United States Constitution says you cannot take private property for public use without just compensation, right? So we're saying, why shouldn't this apply? And I was amazed that there is no federal case law on that. It has never happened in a case that's reached an appellate level in federal court. It has reached the Supreme Court of a couple states, three states. Two of them basically came down on our side. The third one, California, came down on the government side. Right, exactly. Well,
Never happened.
we had summary judgment motions pending on that because there were no facts that were in dispute. And the federal district judge, Bremer, just a couple of weeks ago, ruled against us on that. So there's still some post-decision things that we might do. I can't really talk about that anymore, but just as an update, we lost at the federal district court level. So that's
So
where we're
just to
going
be
now.
clear, the house got destroyed.
House was destroyed.
No one could live there anymore.
House was destroyed.
And so the guy...
He had to scrape it, and he built a new house, but he had to scrape it. Yeah.
They were going to offer him like $4,000 or something.
Yeah, $5,000. Yeah.
Well, it's worse than that, because the city gave him a notice because it was a mess, told him to clean it up.
Yeah, absolutely.
Yeah.
Right. So,
I can tell you, in Afghanistan,
hold
happened in Afghanistan.
on.
All right. Florida would have gotten more compensation from the U.S. government
Right.
than it would have happening here in the United
Right.
States.
What Matt's saying is he's military, army, and he said that if a house was destroyed like that in Afghanistan, the U.S. government would have paid for it. Yeah. Right. So, and I can take all questions about that, but I want to get to a couple other topics. Follow me on Blue Cart. Follow me Twitter. That's where I am. Libertarian critique of the Constitution and the Supreme Court. Now, talked about how philosophy is applied through politics, and right now, I would submit in 2018 in the United States that the philosophy that is used against us by the politicians is that we're all stupid and need to be controlled. That's the philosophy, right? Obviously, that's not very libertarian. And that's why we're here. Or anarchists, either way. No, just the people that want a lot less of the states telling us what to do. Now, I will first acknowledge with this crowd, Lysander Spooner, right? We're going to talk about the Constitution, and for those that don't know, most of you can probably recite this, but I wrote it down to make sure I got it exactly right. He's talking about the Constitution, and he was an abolitionist during the time of, roughly the time of the Civil War. He was a contemporary of the Civil War from Massachusetts. And about the Constitution, he said, "It has either authorized such a government as we have had, or has been powerless to prevent it. In either case, it is unfit to exist." Right? That's Lysander Spooner. I get that. Right? But I just don't want people, when I start talking about the Constitution and Supreme Court decisions, people will say, "Yeah, well, it shouldn't exist." I get it. Right? We're going to talk about some of the history of it and how we went from its original intent, which, I get people saying that was bad to begin with, but at least what the original intent was to where we are now. When I first was talking to Justin about speaking, I was thinking, let me talk about 10 or 12 really important Supreme Court cases and really get into those and the facts of them. But then I started doing that, and I'm like, we need to narrow that down. Let's narrow that down a little bit. So, and one thing but it did get me to think about trying to put together maybe a Supreme Court cases for dummies or Supreme Court cases for libertarians. I don't know, either way, depending on how you want to look at that.
But I repeat myself.
Right, exactly. Because I've done some teaching, and people don't read what they have strong opinions about quite often. I
think people just don't read.
That's true. They don't read at all. Right. Exactly. There's a great example of this. Tom Cranwitter has spoken here before. He used to be a professor at what's the name of that school?
Hillsdale.
Hillsdale. Thank you. And so an undergraduate came to him who was like in charge of the Right to Life organization there on campus, and she wanted to do some big organized rally against Roe versus Wade, right, to get it overturned. And when Tom's talking to her, he writes he's never read Roe versus Wade, right? And that should be shocking, but of course it's not. And like today, I think the best example of that is all these people that are violently, passionately against Citizens United. They have no idea what that is. They know what they've been told by Hillary and Bernie and some other people, right? They have no idea that if Citizens United had been ruled the other way, the government could ban documentaries. I mean, read the damn case, right? And I see kids, some of them, just another recent example, DACA. I see kids really being pro-DACA, which is fine, but they don't know what it stands for, right? They certainly haven't read it, right? So there's a certain baseline of information I think is important. And that's one of the reasons I think it's important to talk about some of these Supreme Court cases. And in particular, I'm going to talk about Marbury versus Madison, because I think a lot of people know what it's supposed to stand for, but does anybody know who Marbury was?
Yep.
You're about to find out.
Stephen Marbury's like that.
Stephen Marbury, yeah, he was Georgia Tech, right, NBA player. No, different guy. I don't even think they're related.
23 points a game. 6
He did go to Georgia Tech, though, right? If I remember that. Because I'm in North Carolina. I went to the University of North Carolina. They play Duke tomorrow. So if anybody wants to go to Blake Street Tavern at 6 o'clock with the Denver Carolina Club, you can find me there. So come on out. All right. What's the basic popular notion of the holding of Marbury versus Madison? Not Matt. See if anybody else can get an idea. What did Marbury Madison? Yes, sir. Are you a lawyer? You're disqualified.
No.
Okay. All right. Go ahead.
To me, it means that that's what gave the Supreme Court the power to strike down laws and say whether they were constitutional.
Yeah, that's pretty much right. So it was the first time that the U.S. Supreme Court struck down an act of Congress because they said it was in conflict with the Constitution. Anybody else know? Not Matt. Who knows who Marbury was? Why was his name on this case? Right? All right. You guys think politics is bad today, and it is, with mudslinging and spite and obstinance and all of that. And who?
And Trump.
Yeah, and Trump. Yeah, exactly. All of that. And Hillary. All of it, right?
Win-wins.
It's basically it wasn't any better in 1800 or in 1776. And kind of the facts and the story leading up to Marbury versus Madison kind of illustrate that. Who is familiar with the musical Hamilton? All right, come on. You got to admit it. All right, my daughter's in the 7th grade at the Denver School of the Arts in the theater department. So I've heard the soundtrack 8,012 times. All right, so I'm very familiar with the musical Hamilton, and I've learned some stuff from it. And that's the era we're talking about with Marbury versus Madison. In the election of 1800, which is when Hamilton was a big deal, right? That's when Jefferson won the presidency. John Adams had been the president. He was the sitting president, one-termer, lost, but he didn't come in second, right? Who came in second? Aaron Burr. Right, Aaron Burr came in second. And between the time that Jefferson finally won that election, which took a long time, right? But between the time he won and the time he was inaugurated, John Adams was like, I got to do what I can. Because John Adams was a Federalist. Jefferson was a Democratic Republican, they called him now. And so in that election for president, the Federalists lost, which I think might have been the last time they lost anything, because since then it's been all federal government, right? The Federalists control Congress also at the same time. So Adams is the president, Federalist, he's lost. Congress is still controlled by Federalists. They're like, oh my God, what we're going to do? Jefferson's about to become president. We don't like that. So they passed an act in between the election and Jefferson becoming inaugurated. What that did was it allowed Adams to nominate a whole bunch of federal judges and some District of Columbia justices of the peace, because that's part of the federal government, right? And the other thing it did was it said that at the time there were 6 Supreme Court justices. They said, well, we're going to cut that to 5. So the next time one of those guys retires, guess what? Jefferson doesn't get to pick them, right? I mean, that's exactly what they were doing. So they wanted to stack the federal government with a whole bunch of Federalist judges. One of those guys was William Marbury. But he was a justice of the peace for the District of Columbia. Kind of a low-level job, but you know, in the scheme of federal government judges, right? Justices of the peace. Anybody watch Andy Griffith's show? Yeah. Andy Griffith was a justice of the peace, right? Probably less important in Mayberry than it was in D.C., but still, that's kind of the level that we've got. Now, Marbury was a rich guy from Maryland, big supporter of John Adams. So patronage has been going on forever, right? That's why Marbury got appointed to this job, because Adams liked him and he supported Adams. Adams was going out, he said, we're going to screw Jefferson. Marbury, take this job. Well, what happened was, while Adams was still president, he appointed all these guys. The Federalist Congress approved all of them, right? Had to do that under the Constitution. And the Secretary of State at the time started handing out those commissions, but he didn't get them all out. Right? He didn't get them all out. And the Secretary of State for Adams was none other than John Marshall, who was the Supreme Court Justice who eventually wrote Marbury versus Madison. That's a whole other issue whether he should have done that, but he did. All right. So they didn't get all these commissions handed out. Jefferson becomes president. These commissions hadn't been handed out, so what does he do? He says, screw these guys. We're not handing out these commissions. Screw that. They're screwing me. I'm not going to hand these out. Well, Marbury was like, hey, no. I got this commission. President appointed me. Congress approved me. All you got to do is give it to me. You don't have any discretion on that. You've got to let me be the Justice of the Peace in the District of Columbia. So he sued to make that happen. It's called a writ of mandamus. Is going to make Madison, who's now the Secretary of State, that's why his name's on the case, make him give him the commission that's already been completely done. He just doesn't have it, so he can't start his job. So
I want the Golden Goose now, Dad.
the golden ticket, right? Exactly. And this, it was for a 5-year term, so and he couldn't be gotten rid of for 5 years. So it's not like Jefferson could have fired the guy. Once he got it, he was in it for 5 years, unless he committed a crime or something. So John Marshall, who's now the Supreme Court Chief Justice, who was Adams Secretary of State, should be a conflict of interest, but he didn't worry about it, heard the case. And the reason Marbury could bring this in straight to the Supreme Court was because Congress had passed a law several years earlier saying that you can bring a writ of mandamus against federal officers straight to the Supreme Court, right? Because most of the time, that's just an appellate jurisdiction, right? You argue in a federal district court, appeal all the way up to the Supreme Court, or even in a state case, you can go all the way up to the state Supreme Court. If you lose it, there's a federal issue. The U.S. Supreme Court can decide to hear it or not. Well, this legislation said that, nope, And this is before all this happened, so it wasn't passed for this purpose, but it had been passed. And so Marbury brought this cause of action straight to the Supreme Court. And so what Marshall did was he said, all right, first of all, does Marbury have the right to this job? And he wrote for a couple pages and said yes. Then he said, is a writ of mandamus, which is an order for Madison to turn it over, is that appropriate? He said yes. Then he got to the question, which he should have answered first, which was, can we hear this case or not? Seriously. And this is where it comes from. He said that that piece of legislation that Congress passed that gave us original jurisdiction, which means it's not appellate, right? You can bring a case starting with us. That isn't what the Constitution says. And so the Constitution says, here's our original jurisdiction, and it's basically between other governments, fights between states, and a few very specific things. Not what this legislation had passed gave them to do, under which Marbury brought this suit. So, what do you do when a statute and a Constitution are inconsistent? At the time, that was an open question, right? It was an open question. And Marshall, he came down and said, hey, if that's inconsistent with the Constitution, we got to go with the Constitution. Now, this was not a gimme, right? This was very much an open question. Now, some people say that this is where the notion of judicial review came into being, like Marshall invented it. And he said, we, the Supreme Court, can decide if legislation is constitutional or not and void it if we say it's not constitutional. That idea had been around. It had been around in common law, it had been around in Great Britain, but it had never been applied in the United States under the Constitution that we had adopted. So that's why it's so important as precedent. But he didn't invent it out of whole cloth. He applied it, and we weren't sure that's what was going to happen. Now, Charles Lee, anybody seen Hamilton know who that is? Charles Lee, a guy named Charles Lee was in a duel with John Lawrence. They were both Continental Army officers. And Hamilton was buddies with John Lawrence. Aaron Burr was buddies with Charles Lee. They were talking junk, right, back and forth. And so they arranged a duel. And Charles Lee and John Lawrence fought. John Lawrence shot Charles Lee in the side. He didn't die. Hamilton, he knew that George Washington was going to find out about this. And George wasn't like down with that, right? He's like, you guys are my officers. We got enough problems. We don't need you guys fighting each other. Right. Exactly. So the guy who represented Marbury in the Supreme Court was Charles Lee. But it's a different guy. Same name, but different guy. I had to look that up. But is that the same guy? No, different guy. But exactly the same name. But it's all the same time period. But what Charles Lee did do was later, he represented Aaron Burr when Burr was tried for treason for allegedly trying to set up a new government west of the Mississippi. So Charles Lee won that one, but he did not win Marbury versus Madison. Since there's no explicit answer in the Constitution about what do you do when this happens, we know that Marshall said that the Constitution wins. Now, this is his language, and I think this is relevant to what Lysander, Spooner, had said when I mentioned earlier. This is what Marshall says. To what purpose are powers limited? He's talking about in the U.S. Constitution. To what purposes are powers limited? And to what purpose is that limitation committed to writing if those limits may, at any time, be passed by those intended to be constrained? That makes sense, right? That sounds pretty good. So, for example, if this isn't Article 1, Section 8, but Article 1, Section 8 lists all the things that the Congress can do, federal government can do. If legislature decides, hey, we want to tell people in...
Can't type ones.
Can't type ones, right, exactly, yeah. They might try to do that. If we want to expand that power beyond that, Marshall's saying, no, you can't do that. Now we know they have, right? Which goes back to Spooner. What good is this Constitution if it's allowed this to happen? So I think the concern that Marshall is addressing is legitimate. And I think Spooner would be down with that. Now, here's what Marshall didn't address, and what Jefferson basically complained about. He said, you know, Well, who gives you, you don't have the power to do that. I know what you're trying to do, but you don't have the power to do that. Because the way I look at it is, Marshall is saying, you guys don't have the power to ignore the Constitution within the legislature. Okay. But what gives the Supreme Court the power to rewrite it? Right? And of course, Marshall would say, oh, we're not rewriting it, right? That's what he would say. That's what all Supreme Court justices would say. But Jefferson said, no, that's what you guys can do. If we don't, there's no limit on this. If you guys get to decide what's constitutional and what not, and we don't, and what's not, if we don't agree with you, what do? Nothing, right? Not in the Constitution.
Who shall guard the guardians?
Right, who shall guard the guardians? Exactly, the watchmen, right? Well, Jefferson had another answer, unrelated to Marbury versus Madison, but he wrote something called the Kentucky and Virginia Resolutions of 1798. So this was even before this. This was before he was elected president. And that dealt with the Alien and Sedition Acts, which basically made it illegal to criticize the president, among other things, but that was a big one, right? These guys had just passed the Bill of Rights with about 10 years ago. 10 years later, they're saying, you can't criticize the president, and that's a crime. Well, that's obviously against the First Amendment, right? You don't have to go to Yale Law School to know that, right? But that didn't stop the Congress from saying that's going to be illegal. And Adams signed it, right? John Adams signed that. Well, Jefferson's like, are you guys kidding me? So Virginia and Kentucky passed these resolutions that said, screw that. We're not going to abide by that. You cannot make us do that because we're states. We are independent, sovereign countries, in essence. And you guys are going to say something like that, we're going to ignore it. All right? That's called the doctrine of nullification. So the Supreme Court can say, that the Supreme Court didn't do that, right? It wasn't involved in this. Before it got to the Supreme Court, Jefferson's like, I don't care what you guys do. States can ignore it if it's not constitutional. So that is an answer to the question, who can stop the U.S. Supreme Court from rewriting the Constitution? The states can. They don't, but they can. Now we'll take some of that back. Because Colorado basically nullified the marijuana law.
Yeah!
Right? Exactly. So it can be done. If you have the right to ignore something that's obviously unconstitutional. Now, of course, what if there's an argument, right? Yeah, there'll be an argument. But if Kentucky says it's not constitutional, they nullify it. Connecticut says it is, they don't. Right? So that's the entire point. There's going to be arguments about this stuff. But giving one branch of the federal government the authority to determine what the Constitution says with no check on that, right? The U.S. Constitution is supposed to have checks and balances. But what Marshall did, according to Jefferson and a lot of the other anti-federalists, was like, you guys are just taking over, right? And so Jefferson had a suggested solution for that. That's nullification. We're going to ignore you. That's not been widely accepted. I think it should be, right? And it also goes to jury nullification, right?
Yep.
So if there's a law passed, say a drug possession law, you haven't harmed anyone, you haven't stolen from anyone. If the judge says, this is the law, this guy, the evidence shows he had marijuana or heroin or whatever it was, and sold it, okay? Nobody's been harmed. I'm not going to get into the drug warrior argument, right? Nobody's actually been harmed. Nobody's been hurt. Nobody's been maimed. Nobody's been injured in any way. The jury can say, well, okay, the law says he's guilty, but we're not going to convict him. We're going to vote not guilty. That's jury nullification. It means the jury has the conscience, has the right to exercise his conscience back in the jury room. Nobody's ever told that. Judges aren't going to tell you that, right? And the lawyers aren't allowed to argue that, because if you do, you'll get in trouble with the judge and the bar. There might be a mistrial. But you can do that. Wayne?
And if you tell anybody before, when you're being selected, that you believe in jury nullification, you will be escorted out of the building. Happened to me.
Before you talk to anybody. Yeah, that's very good.
Yes.
Yeah, all right. So we'll get into some more of that. There were some guys arrested in front of the Denver courthouse who were handing out pamphlets about jury nullification. FIJA is an organization, fully informed jury association. One of the things they do is they try to let people know that you have that right, even though nobody's going to tell you that. They might even tell you you can't. Well, you can, because whatever you do back there can be corrected. You know, that's the point of the jury. The jury is one of the big bulwarks against an oppressive government, right? And so that's one of the things that Jefferson is talking about. So this is something Jefferson wrote later, talking about the Marbury versus Madison decision, and John Marshall saying, we get to decide, and there's nothing you guys can do about it, right? We're the Supreme Court, we get to decide. Jefferson said, you seem to consider the judges as the ultimate arbiters of all constitutional questions. That's exactly what he was saying. This is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have, with others, the same passions for party, for power, and for the privileges of their core. Right? I think Jefferson nailed that. Absolutely. So I think Marshall was right in what he said. The legislature can't ignore the Constitution. But then Jefferson is right saying, well, you don't get to decide what the Constitution says. So what's left? I submit one of the things that's left is nullification.
Yeah.
Right. So
Yeah.
that's, I think, a good concept that most people aren't familiar with. I mean, in this group, you guys probably are, right? But most people are not that familiar with even that idea that it's possible. Now, what Jefferson was concerned about the judges of the Supreme Court, justices of the Supreme Court, being able to decide whatever they wanted, that came true. It's true now, right? And I think, I submit that it reached peak absurdity in 1940 and has stayed there. It hasn't gone down any since U.S. Supreme Court ruled in a case called Wickard v. Filbert, which some of you guys have probably heard of. That's the case where FDR was setting out all of these price controls, right? He needed to control the government and the economy, because the economy was bad, so obviously we need central planners to decide how much wheat farmers can grow. That will solve the problem, obviously.
Obviously.
Right. Right. So that's what he was doing. And so he put limits on how much every farmer could grow. And Wickard was a farmer growing wheat, and he was told he could only grow so much. Well, Wickard wasn't selling his wheat. He was using it on his own farm for his family and for his livestock. So, not only was he not selling it, right? Not commerce. It's not being sold. It certainly wasn't interstate because it was staying on his farm. So we've got the U.S. Supreme Court saying, and they ruled that he had to abide by the limitations passed by Congress because of the Commerce Clause, Interstate Commerce Clause. That's one of the enumerated powers, Article 1, Section 8. So we've got these really smart justices on high in their oracle building, right, saying that an activity that is neither commerce nor interstate is regulated because it's interstate commerce. That's literally what they said, okay? That is like saying, if some physicist says the sun is the moon, we're not going to say, okay, that's ridiculous. Well, what the Supreme Court did in Wickard v. Filbert is just as ridiculous as that.
Yep.
But it was an expansion of government power, which is exactly what Jefferson was worried about, and a lot of other people were worried about, and it has happened. And that's the law today. And so we saw it play out in the Obamacare case up to the Supreme Court, because Obama's lawyers were saying, hey, Commerce Clause, if we tell you if you don't buy something, which isn't commerce, right, we're going to fine you for that. We can do that because of the Interstate Commerce Clause, even though you're not buying anything, right? They make this with a straight face. This is what they argued. The U.S. Supreme Court said, nah, we're not going to go that far. But the whole time you guys were passing this and said, this was not a tax, well, that's what it was. Yeah. So you've got the ability to tax, so you can do it because of that. But that's the last time that the Supreme Court, one of the few times the Supreme Court has not let the federal government do something under the Commerce Clause, because even that was too far for the U.S. Supreme Court. There's one more. I'll get to you guys, absolutely. I'll try to wrap up because I know there's a lot of questions. There's one more. U.S. District, the federal Congress, U.S. Congress, passed, tried to outlaw guns within a certain limit of schools in the District of Columbia, because that's federal property. They can do that. And so people were saying, what authority do you guys have to ban guns around schools? What'd they say? The Commerce Clause. Seriously.
Is there an open air gun market?
no gun markets. And what they said was, this is serious. And this is why I'm going to get to De La Boetie momentarily, because this all ties into Etienne de la Boetie. The U.S. government lawyers argued that if students in schools, in public schools in D.C., were worried about gun violence, they wouldn't get as good an education, and then they wouldn't be as productive, and therefore that would affect interstate commerce. I'm not making this up. I'm not making this up. That's the other time the Supreme Court said, we're not even going to go that far. So the Supreme Court did say, no, you can't, that's not going to fly. But it doesn't, it shows you the ridiculous levels that Wickard v. Filburn has allowed into our jurisprudence, has allowed into our government, and it's rare when the government stops it. That's why the federal laws against marijuana are still applied. It's because of Wickard v. Filburn. Exactly the same rationale. All right? Now, and I ask you guys this as a constitutional issue, philosophical issue, a governance issue from a libertarian point of view. When we had prohibition, the legislature in the states had the decency to pass a constitutional amendment because they knew there was no legitimate reason to ban alcohol throughout the entire country. Not in the Constitution. There was no legitimate power to do that. So yeah, we need an amendment. And they did. They got the amendment. That's the way the process is supposed to work. Yeah, they realized how bad an idea that was, and they undid it. But in the 70s, when Nixon declared the war on drugs, that idea is gone at this point because what's happened? Wickard v. Filburn's happened. So now we can just ban it, right? So that's been upheld. And Scalia upheld that. Scalia was on the side of the federal government on that. The only dissent was Thomas. So props to him. This goes to Etienne de la Boétie. Who is familiar with Etienne de la Boétie?
Why don't you give a brief synopsis?
Yeah,
What time for, okay.
He's a French guy from the 1500s.
1500s.
Yeah, 1500s.
Crazy.
Okay, before the U.S. was a thing at all. Before we were colonies.
Yeah, seriously.
He was a French aristocrat, a politician, a judge. He was in the ruling class. All right? And he wrote this essay. It's about 50 pages, I think. Discourse on voluntary servitude. And his whole point was, why do people let tyrants control them? Right? It's a great essay. It's for free on the internet. Mises has got a great PDF version of it with an entry of the introduction by Rothbard, which is great to read as well. So his basic statement, after discussing all the things that tyrants do and how they can get away with them, is that tyrants get away with it because we let them, right? Because we comply, because we do what we're told, right? There's not enough power that the tyrants actually have to stop everybody or to make everybody do what the government tells them to do. So, without consent, the tyrant doesn't exist. Goes back to Thomas Jefferson, doesn't it? And the consent of the governed idea. So Thomas Jefferson talked about the consent of the governed. De la Boétie said, without giving consent, they don't govern you. And but De la Boétie is saying is that you don't have to actually say, okay, I consent. You consent by complying. That is your consent, by doing what you're told, right? And I know this is a dangerous concept. You can ask Eric Garner, you can ask Lavoie Finson, right? They were killed by government agents because they didn't want to comply. They were not consenting. So that's serious shit, right? But if enough people do that, there is no more power of the state. Now, Boétie did say, this is a quote from him, "I don't ask that you place hands upon the tyrant to topple him over, but simply that you support him no longer." Now, I think that's a true statement, but the problem is you've got to get enough people to do it. But the power is there. You've got to have enough people to do it. You guys have probably seen that there's a little one-frame comic strip, which has got a guy on a lectern, talking. He's clearly the leader, talking to a group of people, and he's out over a cliff on a board, right? But everybody he's talking to is standing on the board, keeping him out there. And then one guy walks out, right? That guy is no longer consenting. Now, nothing's going to change because he leaves. But if enough people stop it, there is no more power in the leader. So that's what De la Boétie is saying. And I think Jefferson had that concern. Marshall had that concern, although his answer was to give it to him, right? Just trust me, I'm the Supreme Court Justice, I'll keep it all cool. But we see that didn't work because the Supreme Court later completely ignored the limits placed on the government, which was Marshall's concern Right. And he said, let us handle that. And it was the Supreme Court that eventually said, oh yeah, you guys can do whatever you want, basically. So I think there's no easy answer on that. There's no easy thing to do to apply that. But I think it's important to understand it. I think it's important to know it is a problem. I think it's important to understand that the concept that Wetty was talking about and that Jefferson was talking about with nullification. It's important to understand those things because even though there's not a simple answer, I don't think most people even know that it's a problem. So if we can get people to understand that that's a problem, that you don't have to comply, that's the start of real change. So I'll open it up. Thank you.
Dave.